I mean, if you put something into AI, you can, what comes back is just like, wow, that's better than anything I could have ever written. It gives you the answer you want. The oldest con man rule in the world is the easiest con to make is the one where people want to believe it's true. Hello and welcome to the next episode of Beneath the Law. Gavin Tighe with Stephen Thiele. Stephen, how are you?
I'm doing pretty good there, Gavin.
And I can tell you that this is the real Stephen Thiele, not the robot.
Not the AI generated one?
That's right. The one, the only Stephen Thiele.
Well, I'm doing okay. You also don't look like you're AI generated, and I hope you're having a great day. But I understand there are actually programs out there that allow you to create AI attributes for people.
Yeah, I could use a few attributes like intelligence. If they, yeah, like I have the artificial part down, but the intelligence part still eludes me. So today we're going to talk about the advent of AI and its impact on the legal world. It's been pretty dramatic in terms of the number of cases. We talked about it before, but the number of cases that are popping up all over the place, like mushrooms after a rainstorm, or they leave the sprinkler on too long. And AI is the biggest cheat ever. I mean, it's an easy hack for people to sort of not do any work. That's what I think.
Gavin, I continue to shake my head at what is going on. And this case in particular, it comes out of England, a very, very well-renowned international law firm with a great reputation, like a stellar reputation in terms of its representation
White
of clients.
shoe, as they might call it in Manhattan.
And, three lawyers basically walk into a propeller because the junior lawyer on the file is basically having a chat with artificial intelligence to answer a legal question and gets it wrong.
Yeah, I mean, okay, so let's just sort of backtrack on that. So what we've got is, I guess, we can get into the specifics, but it was an insolvency case, as I understand it. But basically, this is not an uncommon situation. You get in a law firm, you get a technical point. You oftentimes will go to the junior lawyers in the firm and say, I need some research on this or that or the other thing. And they come back with a memo or what have you, and they've given you what the law is. And, and quite frankly, it's not uncommon, particularly in larger firms, it percolates up the food chain. The senior person's name ends up on the brief or on the letter or what have you. They had precious little in terms of the actual creation of that, although it sounds good, and they go with it. And they don't, I mean, in fairness, it would be impossible to review and research. Are you sure you got that right? If you did that, I mean, what do you need juniors for? So the whole point of having a law firm and an apparatus in the firm is in order that you have that ability to generate that kind of work. Because if you had to do all the work yourself, everyone would be a sole practitioner.
No, but it's Gavin, just on that point, I mean, if I think back to my days as an articling student 37 years ago, the senior lawyer did take the time to actually sit down with you and go over your work.
Yeah.
And I think what has begun to happen in this evolution of law is that we are working at almost lightning speed on files. Everybody wants an answer, the same day or yesterday. And so people aren't doing what would have happened in a very, very traditional practice 40 years ago. And people aren't checking. And worse, this case really shows something in terms of standard practice. Didn't inform anybody up the chain as to what was happening at the bottom end of the chain.
Well, nobody checked. I mean,
nobody checked, right?
So maybe you can give our listeners just sort of a brief background of what happened here. I will say that the particulars of what happened here are interesting, but they're not that different. I mean, you could change the area changed the way it works. But why don't you tell our listeners what went on? And the firm, I think, was Pinsent Masons in London, and they certainly took a black eye over what happened here.
Yeah, they're headquartered in London. So look, if you already alluded to it, it arose out of an insolvency proceeding in England. There was an application that was made. It's called a block transfer application. And essentially the way that I understand that, and for those who actually practice in insolvency in England, please don't jump down my throat if I get this wrong.
You should have used AI.
Yeah, I should have. But this kind of an application essentially allows, a trustee in bankruptcy to have their responsibilities transferred to someone else because they're either retiring or switching law firms. There's a process under the Insolvency Act or insolvency rules in England that permits that to happen. And part of what I guess is standard in the order is that you release that office holder from liability. And so it's clear under the legislation that when there's a performance of an administrative task, the release is not a problem. There's actually an express power under the legislation to allow that to happen. But on other issues, i.e. liquidation issues, that power is not as clear. So the court decided to ask Pinsent Mason lawyers, and this is an uncontested application, which I think is important.
Right.
Where the authority came from this draft order for the release of both administration and liquidation matters. And the work went from a, I guess, senior associate down to a junior level associate. The junior associate began to chat with AI. We're not clear what the platform was.
Doesn't matter.
Quite extensively. There's like a 59-page transcript at the end of the day and answers the question, flagging a rule that actually the language in the rule didn't exist. Presented it as a quote to the judge in a letter, went back up to the senior associate. She didn't know that AI was used, signed off on the letter. She questioned whether it was right or not, but didn't do any other research. The letter goes to the judge, and the judge is stunned by what he has seen. Goes back to the law firm again to clarify the points. And
pointing out that that's not what the statute said.
Right. Well, the judge had done their own research.
Well, they looked at it and said, that doesn't sound, I mean, it wouldn't be, that's not unusual. Judges are not, well, I mean,
they're not rubber stamps.
No, well, there's cases, as we've talked about, on that too. And there was a recent case in Canada where an arbitrator just bit on a fake citation, and that was the grounds for overturning the arbitration.
It does happen.
Judges do, for the most part, they do, they go, wow, that doesn't sound, there must be that doesn't sound right moment. And then they go and pull the book themselves and go, that's not what it says. And then they went back to the firm here and said, are you sure? And they came back and said, "Oh, well, we're not."
It was a summary, but we're sure, kind of.
Yeah, but we got it right in substance, but it's not a verbatim quote. It was completely, as I understand, it was completely just made up. Sounded good though, apparently.
Yeah,
good enough to get through twice through the law firm.
But here we are with the use of AI, and there's a couple of points. Gavin, my job, as you know, is I do background work. I'm a research guy, and I've built my career on that in terms of following a very, very traditional research methodology to find answers to legal questions. I know the sources where to find the answers, and if I don't, I spend the time trying to learn what sources will help me find the answer. I read a lot, which is why my eyes are shot now in terms of being able to read without reading glasses or cheaters. But
you get the surgery. I got that. It's fantastic.
Yeah, I don't know. I'm not a big guy on the surgery front.
It's a bit creepy when you think about it, but it actually works fantastic. Anyways, we digress.
But anyway, here we had this junior lawyer engaging in a 59-page chat with the AI to basically answer the questions. And now, in fairness to the AI platform that was used, was telling the lawyer to check and verify.
Yeah, but I mean, I think, look, I mean, this AI is pretty cool. Like, I mean, I got it. I mean, I'm, as the old guy here,
It's a nice disclaimer of
it's
liability.
yeah, I know, but it spits a wicked yarn. I mean, if you put something into AI, what comes back is just like, wow, that's better than anything I could have ever written. That's fantastic. I'm completely persuaded. And the only other thing I find about it, if you read it, it tells you what you want to hear. It gives you the answer you want. So it gives you the answer that you're going to win answer, ultimately, and which is, the oldest con man rule in the world is the easiest con to make is the one where people want to believe it's true. That's what, it's like, Bernie Madoff didn't make all his money by, well, he tells people you're going to make money, and everybody wants to hear they're going to make money. So it's the same with AI. I find that it will often come back, if you look at it uncritically, it comes back and tells you exactly what you want to hear, which is apparently the same in this case, because what the AI came back with was what the answer that the law firm wanted, which was, here's the theory to
And
support
express
what you
power,
want the
right.
court to do. So, that I think is, you have to be a complete skeptic at this point with AI. It isn't, it's got the A part right, but the I is still a little wonky. And you need to be, the man from Missouri, so to speak, when it comes to AI.
As I teach our students here at our firm, Gavin, AI is just an aggregator of information.
Right.
And, with, I guess, the added element that it predicts words and that it sounds good.
It does
But
sound good. It
but
does
just
sound really good.
right, but just because it sounds good doesn't mean it's
No, but
legally correct.
yeah, I think that's really
And that's the
important.
problem.
That's such an important point, that people think that AI is like this actual, like, thinking being. It's not. What it does is it's a predictive model based upon predictability of outcomes, and what it does is it's able to do math really fast. And what's the likely answer? On a preponderance of possibilities as to what would be that, and it does that instantaneously. But it's not thinking, so to speak. It's just basically knocking off options and giving you an answer based on what it believes is the predictive model.
It's putting a bunch of words together and, as a lesson to young lawyers,
Yeah, don't be. And the other thing too, I always think about
like,
is,
stay away from AI.
well, don't be so quick to run
For
into the
legal
propeller.
issue.
I mean, you're basically, when you hand off what you do and the value you bring to the equation to a machine, don't you make yourself completely redundant? I mean, what's the point of, if AI can do, if you believe that AI can do a better job than you can? I have to say it does come back pretty good sometimes. Um, you make yourself irrelevant, don't you? I mean, why would you ever want to do that?
I don't know about that, but it's almost to me, it's almost a reflection of we've lost the ability to socialize and actually talk to one another and bounce off ideas off of real people
Right.
instead of, oh, well, you know what, I can bounce my ideas off of a inanimate AI program.
Yeah. No. Well, if look,
It's
I
my best
think.
friend.
Well, yeah, okay. Look, I have a different view of it. You and I are of the same vintage. I remember when we first went to law school, and it was the first advent of computer searches on legal databases. It never happened. You used to have to go to books in the library. That was it. And then I remember courts were uh, quite adverse to computer searches of databases. Now it's everywhere. Now you're negligent if you don't do computer searches. Now you have way more access to case law than you did, when we first started practicing 30 plus years ago, because if it wasn't a reported case, nobody knew about it. Now it's like every single case is online and you can find it. I mean, it is a far superior model and a far broader, sampling of judicial thinking in terms of case law and precedent than we started with. And I think AI is probably in the same infancy that original computer reported cases were.
Well, look, one, I hope that's the case in terms of the evolution of AI actually giving correct answers and not giving wrong answers.
Yeah, well, you're
However,
gonna look. You
how,
got this boat is leaving, and if you aren't on, I mean, I think my own view is AI is here and it isn't going anywhere. And I think what we've seen certainly is, a lot of errors and mistakes and people, frankly, just being lazy, and not reading the cases to check on what AI is doing. But on the other hand,
or the legislation.
on the other hand, I think that if, as with many other things, there will come a time where if you aren't on the AI train, you're going to get left behind because I know for a fact that many large firms are developing their own AI. They have to, and they don't want to be left behind. That there is a incredible tool at their disposal that they better use, or their competitors will use it and leave them behind.
Look, Gavin, I don't disagree with that. Hopefully, by the time that comes, I'm long gone from the practice of law because no, but it's
Don't count
look,
on it. The rate of change if things are going, and maybe next week.
it's well as if then I guess I better pack my bag sooner in
Not
terms of
going
that.
anywhere.
But I'm somewhat doubtful that we're going to see anything happen next week. But at the end of the day, Gavin, you still have to do the human checks. You can't just be reliant on what is being spit out of the computer at you.
No, I mean, and I come back to, it's like the same old, same old. You go to court to argue a case, and I wish there was a shortcut. I've been looking for a shortcut for 34 years. The shortcuts, there aren't any shortcuts. You got to read the cases. You got to understand it, because when you're standing up there and you're the one making the argument, it's not ChatGPT that's making the argument. You're making the argument. When a judge asks you a question, you better be able to pivot and answer it. And you have to have some basis of knowledge to do that, or else, you know what? You look like a fool. And you're not effective. So I agree with you. I mean, there, as much as nobody would like to find a shortcut more than I would. I don't know that there are any. I don't think there. I think at some point in time, the information, whether it comes from AI, whether it comes from air, has got to get from the computer screen, the paper, the book, the whatever, into your head, so that you can actually make the submission. As long as we're in the world where oral advocacy is how courts are dealt with, and as long as we're in a world where lawyers have to stand up and make arguments in front of human judges, I think that I don't know. I don't know that there is a shortcut. Although it is this bright shiny object at the moment that I think everybody is attracted to, including I would love to see more use of it to narrow stuff down so that perhaps the answer is there's less to read, or that there's less. It makes your job a little easier, and it saves some clients money in the process.
Look, I think there are certain applications of artificial and technology in the law that are extremely helpful in terms of, reviewing a contract to find if there's a specific provision in the contract.
Right.
Aggregating thousands and thousands of emails and then, asking what email mentions Gavin Tighe,
Yeah.
for example. That is tremendously efficient. But in today's world, to use AI to conduct legal research as a shortcut has significant risk. And, we're seeing that. You talk about judges, live judges, we've got judges who have used AI to produce judgments. I haven't heard that much lately, but
No, you haven't. And that is, I mean, in fairness, I mean, they're human
bad.
too. And I mean, they suffer from the same attraction to the bright, shiny object as the rest of us. And, I think it's only a matter of time before you're going to have cases. It's a worldwide phenomenon in terms of lawyers being caught wrongfully using AI. But it's only a matter of time before a judgment is found to have been written by an AI bot. And, I mean, you can hate the sin, but love the sinner, as the saying goes. And you can understand why people would do that. It's attractive because it is easy, And it is a slothful, but it's an understandable sin. People look for shortcuts all the time, and judges are people.
I know, I guess maybe I'm an outlier because I always look how to do things the hard way instead of the easy
No,
way.
but that's why you're good at
But,
what you do.
well, thanks very much. I
But that
appreciate that, but
that dose of skepticism, I think, is what's missing. I mean, we also have a generation that is raised on, if it's on Google, it must be true. And, I think that is one of the things I personally have a lot of difficulty believing a lot of the things you read online. Most of it's baloney anyways. Most of it's not true. Certainly most of the things you read on social media. I wouldn't believe 10% of it.
no,
But I
look,
think,
it's healthy to have a dose of skepticism, right?
yeah, I mean,
With respect to anything.
sure. And I mean, I think particularly with regards to law, if it's, when you're making the argument, I think ultimately one of the things that lawyers, especially young lawyers, have to understand is it's your name is on the brief, or you're the one standing up in court making the argument. It's
Right.
your argument. You know what? If you used AI or whatever to get it, well, whatever, but you own it at the end of the day, and you're the one. If it's wrong, it's going to land on your head, and if it's wrong because you didn't do the work to read the cases that you put your name to, too bad for you. You're warned. I mean, now, for example, in Ontario, you've got to sign the factum that says you've checked the sources. You've got to
But
give
that
a
doesn't happen all
certification.
the time, right?
People don't do it.
Right. People don't do that.
But they're required to do it.
They're required to do it, but they don't.
But I've seen it on these cases where I've been dealing with a number of these recently where, lawyers have been hauled up on the carpet by the court. And one of the questions is, why didn't you sign the certificate? We know now that these were hallucinated authority. You didn't sign a certificate. Coincidence? I mean, you didn't do it and you didn't say you did it. I mean, when you were required to. It really is a road to perdition as far as how to quickly lose your law license.
Well, you know what? It's very interesting. I haven't seen a case yet where a judge says that the certificate wasn't signed. I don't know if clerks at the court now, before they allow documents to be uploaded to the case line systems or filed with Court of Appeal, are rejecting it if you don't have the certificate signed. I haven't heard of that yet, but maybe that has to happen.
Well, I've seen it happen. I've had a case where it wasn't signed, and then they turned out that they was hallucinated cases, reported cases.
Right, but the material wasn't sent back to the lawyer that filed the material to say, "Hey, sign the certificate."
No, because it went to the court. That's what
Right.
the judge said.
There we go.
These aren't cases aren't real, and you didn't sign the certificate. So,
So
but it's
we're
not,
seeing that.
we are seeing that. We have seen that. I mean, I think the mess. I mean, certainly certain judges, certainly in Ontario, have been pounding the drum. They can't, and and speaking with them, they can't believe it's still happening. But it's going to keep happening. I mean, I have to say, I think it will continue to happen because I think that as soon as there is an easy route, and it's a, as I said, I think it's a sin of laziness, and people will take the path of least resistance. If it's an easy way to do it, they're going to do it.
Well, it's either a symptom of laziness or a symptom of working in a high pressured environment and having to turn around and answer in a short period of time. And
And there's a ton of pressure, right? Like,
tons of pressure.
I don't think we're excusing the behavior when we talk about this at all. I mean, it's certainly if anyone's taking that's what I'm saying. That's not what I'm saying. But I cannot excuse the behavior and still understand it. And I think that there's an enormous amount of pressure. I mean, this was as we called a white shoe law firm out of the UK. It would be interesting to see their accounts to see if the lawyer had billed for preparing the memo that was wrong, and if they refunded the client for the fee they charged. But you can see where lawyers who have an enormous amount of time pressure and monetary pressure to churn out work where they may or may not be getting paid for it, and they have concerns about how much they're going to be paid. All sorts of family law where there's all sorts of pressure. There's not a lot of money to go around, and there's an enormous amount of work to be done for what is relatively small amounts of money. I mean, that pressure, that economic pressure, that on younger lawyers in particular, you can see why, this becomes very, very attractive. They're overworked. They're worried that they're going to get paid, and this just seems like an easy way to get the job done.
Well, and especially too, Gavin, I don't know the UK experience going to law school, but certainly, we turn out lawyers here in Canada. Some of these kids are coming out of law school, hundred thousands of dollars in debt, right?
Yeah.
So there's lots of pressures immediately in their first year of practice, and
And that
1,600, 1,700 hours of billable work. Multiply that, add 3 hours for every 10 hours of work, right?
Yeah, and that's in a large firm model where the billable hour matters.
Is maybe
in the
right,
day-to-day, in
higher.
the trenches of your average lawyer. I mean, most lawyers don't work in large firms, but the vast majority are sort of hand to mouth. They get paid oftentimes a percentage of collection. And, when you're talking about collected money, I mean, you're really sitting there going, I really want to spend 10 hours reading all these cases, which the client will maybe pay me, a couple $100 for because that's all they got? Or am I going to run it through an AI model and get the thing out the door? You can understand that the pressure with respect to dollars and fees collected is enormous, even more so than it is in, just doing, if your pressure is just to put the time in, then you've got an incentive to put the time in. But if your pressure is to actually collect money, I mean, that's a far, more difficult thing to do than just bill hours.
Yeah, no kidding. It's all part of the business of law.
It is an enormous, part of the business of law. But what we're seeing is, and I think I'm hopeful that, and I think that AI will evolve. I think it's going to be around for a long time. I think it's going to replace a lot of lawyers as it becomes more dependable, just like legal, computer modeled research did. You still got, but I still got, you still got to read the cases. And
it's not going to happen next week.
Well, maybe not next week, but the pace of change is, to me, as an old guy, man, it reminds me of one of those old Bugs Bunny cartoons with the snowball rolling down the hill. It's just getting bigger and bigger and faster and faster.
So, we're coming up here on probably our time to end this discussion. But one of the things that I think is really important for law firms is that they have to have, and accounting firms too, and other professional firms, you have to have robust AI policies in terms of when should somebody use it, if somebody's using it, to report that up the chain. Because that is really important. And I think that's one of the biggest failures here is that nobody was actually paying attention and asking the questions.
They're passing it off as their own work. Well, I tell you, I think what the message here is, if you're going to pass AI off as your own work, be careful what you wish for. Because if it's wrong, you wear it. And ultimately, I think if people get that message, then maybe we'll have a little bit more surveillance and a little bit more healthy skepticism as to the bright, bubbly object and the wonderfully prosaically written memos that come out of AI. Anyways, another salutary tale and cautionary tale of why, if no one is above the law, everyone is beneath it. Thanks, Stephen, for a great discussion. Thanks to our producer, Doug Downs. And also, please rate us. We love to know that somebody's listening as we bellow in the wilderness about these erudite topics of legal interest, at least to us. And if they're of interest to you, let us know too. And if they're not, tell us that too. Maybe we can actually talk about something you are interested in and entertain and inform, which is our objective. Anyways, until next time, thanks for listening.